In my view, here's something that nobody wants to hear. You could have the wills, the trust, the powers of attorney, and all of your legal documents in place. And at the same time, your family, your children can still be subject to unnecessary probate and unnecessary taxes after your death. Because having these documents and having a plan that actually works the way you want it to aren't always the same thing. My name is Patrick, and I've spent the past decade working with executives, high income earners, and business owners in the world of financial planning. And there tend to be the same 6 cracks in their will and estate planning that I see over and over again. So today, we're going to look at why the plan that you put in place and signed up for years and years ago might not actually protect you and your family the way you think it should. A tax trap that could quietly be draining millions of dollars from your estate, and why a judge, not you, might end up deciding who raises your kids. So the first one, your documents are outdated. If we're being honest, when was the last time you actually sat down and read your will and trust, your powers of attorneys, who your guardians were for your children, and asked the question, is this even what we want today? If your answer is a few years ago or I can't remember, then stay with me, because this is more important than you might realize. I've seen it too often. Life moves fast. There's marriage, there's divorce, there's kids going off to college, there's kids that go and get married. Life changes and it moves at an incredibly rapid pace. You built a business, you bought a business, you sold a business, your net worth doubled, but every single one of those can very quietly become cracks in what was once a great plan. Estate plans are not set it and forget it documents. They must match what's important in our lives today. I've seen it where an ex-spouse is still a beneficiary. We have an executor in the estate that actually is no longer living, or we have trustees that we no longer want to fulfill that role. An outdated plan, in my opinion, is just as dangerous as no plan at all. Number 2, we see trusts that have planning in place with no A, B planning set up. Let's unpack what that means. This often catches couples incredibly off guard, and especially as your estate value grows, the importance of it grows along with it. And the cost can actually be tangible dollars that your family never gets back. So I've used this example in other videos, but let's talk about Mr. and Mrs. Wonderful. Their estate is well into the millions. So the first spouse dies without planning, and the surviving spouse loses their partner's estate tax exemption because they failed to do proper planning. If you lose that exemption and the government comes and changes the laws, right, and they bring that exemption value down, and we're subject to that new exemption value, knowing that today the tax rate is 40%, right? So exemption values, they might go up, they might come down. The tax rate of 40%, it might go up, it might come down. But now we could potentially be subject and exposed to a greater taxable estate value than if we did our AB planning to begin with. That's money that now goes to Uncle Sam instead of your family. So why AB planning? Well, number 1, we're able to get some creditor protection built into our estate today. We're also able to shelter and bypass some potential estate tax. And it locks in both spouses' exemptions while they're still living, or the ability to capture those exemptions while they're still living. This is not for everyone, but for the family that plans or intends on leaving a large legacy and they want the majority of those assets to flow to their kids instead of the government, it's a conversation worth having. Was your plan written before the TCJA changes? If so, that's a good sign that you should sit down and reevaluate. Number 3, the trust that you set up is empty. Shockingly common, and one of the most frustrating things I see, is families go through all of this work to do this really great planning and set up a trust, and then the trust remains empty. When we talk to these families and we ask, well, what's inside of that trust? We often get blank stares. And that right there is one of the reasons we've built our planning process the way we have, where it goes beyond just the numbers of can you retire. It goes into further and further depth to make sure all aspects of your financial lives are intertwined. It's a structured conversation where we look at what you have, your wills, your trust, your gifting, your lifetime gift exemption, your powers of attorney, your beneficiary designations, and we're able to have a conversation in plain English, whether you believe it still fits your lifestyle today or if changes need to be made. And so what's the point of this? Because the trust only controls what's inside of it. And if that trust remains empty, then we have this document that can't really perform its duties. So we have a house, a vacation property, we have investments, and we have this trust. And what it is, because those assets haven't been moved into the trust, it's really just a nice piece of paper with a cover on it. And the result is that your family could still end up in probate. And all that money you paid for the trust really wasn't money well spent. And funding that trust, it shouldn't be optional unless that was a really detailed and specific decision you and your spouse made. It's just step 2 of the planning process. Unfortunately, a lot of the couples we work with never make it there. Crack number 4, couples say, well, my will then create the trust, so I'm good. This to me is one of the bigger misconceptions out there. Let's clear that up right now. So that's what's known as a testamentary trust. And this is a trust that gets created upon your passing. And many people think this is going to automatically shield their family from probate. And the reality is, it does not. The will itself goes through probate first, and after that process is completed, the trust is then funded. And so the family is now right back in it. They have this added cost, they're in the court, they have these public records, and they're not able to actually move on and mourn and grieve the way we'd want them to. So a testamentary trust, it does have its place, but it's not the only tool we need to use when it comes to planning for the passing of a spouse or both spouses and that probate process. What we want to look at is possibly adding a funded revocable trust today. Number 5, age attainment versus lifetime protection trust. It's not about you. It's about your kids and whether that money survives in their hands. So what is an age attainment provision? I see it often where couples say, I want my kids to get 1/3 of the money at age 25, 1/3 at age 30, and 1/3 at age 35. Now this isn't perfect and this isn't for everyone, but it's a common planning tool that we see utilized. Why do couples use this? Well, many times it can be to protect one of their children against divorce. If you picture someone that gets all of that money at age 25 and they got married at age 23 without proper planning in place, and the worst happens, a divorce comes down the road at 25, well then your estate that you worked so hard for and you really wanted to bless that child could actually now be split, that inheritance be split in manners that you never intended or wanted. So how do we solve this? I call it a lifetime protection trust, but it's also known as an inheritor's trust or a dynasty trust. So why would we do this? Because we can keep assets in the trust, but then the child still has full access and control over that. We can use it for their house, for education, for retirement funding, for buying and starting a business. We have many options and lots of flexibility with this. And at the same time, we're walling it off against divorce or creditors or unforeseen circumstances. Number 6, there's no guardianship or incapacity planning in place. And this one's an incredibly personal one because almost every plan focuses on what happens when you're no longer here. This one addresses the question of what happens if you're still here, but you're not mentally or physically able to make some decisions about your own life. So let's use the example of you have minor kids and you have no guardianship in place. Then a judge or a courtroom could be the entity or the body that is driven to make that decision on your behalf. Incapacity, you have injury or illness and you don't have the right documents in place, well then your family, your loved ones might not be able to step in and make decisions the way you'd want them to. So we need 2 documents here to solve this problem. We need what's known as a durable power of attorney and we need a medical power of attorney. Without them, the family ends up going to court, racking up attorney fees and paying doctors' bills. It's a slow, expensive, and draining process on the family members that are here to care for you. And so why do we do this? Those powers of attorney, they're not a burden, they're not cumbersome. In fact, they're actually a gift. The guardianship is the same thing. It is a gift to your children in the event that the worst happens to you. Now, I believe all 6 of these doesn't necessarily solve everything, but it builds a very strong foundation to protect your family and your legacy. What this doesn't do is necessarily address the leaks that could be in a financial plan on the actual financial side. And what we see is many plans have a leak of taxes, where couples are quietly losing money to taxes without even realizing their steps and moves they could be making to mitigate this. One of the things I've seen is that most high income earners and really disciplined and diligent savers have never had anyone sit down and walk them through the math of what a really good tax hygiene plan could look like. This is why in the next video, I'll show you exactly the moves we can make to keep more money in your pocket and give less of that money to the IRS, given where we sit in the world of taxes today. Click here and we can do that math together.